Hi, I am Lindsay Sharp of Lindsay M. Sharp, PA, also known as Sharp Law in Indialantic, Florida, and I'd like to speak with you today about child custody laws for unmarried parents. It is increasingly common for unmarried parents to have child custody disputes. When this occurs, a petition to establish paternity will need to be filed. A petition to establish paternity can be filed by the natural father, by the mother, or in very rare instances by the child him or herself. It is of vital importance for the biological father to move to establish paternity. At a minimum, a biological father should ensure that he is named on the child's birth certificate. But keep in mind, that is not an adjudication of paternity. In order to have rights of access or decision-making on behalf of a minor child, the natural father will have to have paternity formally adjudicated in a court of law. Once paternity has been established, a father will then have parental rights to a child. With that, the parents can enter into a parenting plan or have a parenting plan determined by a court of law. A parenting plan will address issues of parental decision-making for a child, whether it's going to be shared by the parents, whether one parent will have what we call shared parental responsibility but with ultimate decision-making authority, or whether one parent will have sole parental responsibility. A court will only award that once it finds that it's detrimental to the child for the parents to have shared parental responsibility. In addition to the decision-making powers of the parents, the parenting plan will also address the time-sharing arrangement, where the child will be spending his or her time and with whom. It's important to have a parenting plan that addresses parenting either on a temporary basis or on a permanent basis. The parenting plan will help to eliminate conflict between parents, such as one parent withholding the child from the other or making a unilateral decision that cannot later be undone. The court will not presume either a mother or a father to be a better parent. The statute makes it clear that the court is gender neutral in its adjudication of what's in the best interest of the child. In Florida, child support is determined by examining the income of the family and comparing that with the number of overnights that the child is having with either parent. For example, if a child is with one parent 80% of the time, then the child support will reflect that the child is spending a substantial amount of time with one parent, and the other parent, the obligor parent, will likely have an increased amount of child support. On the other hand, if the court awards equal time sharing, then the incomes of the parties relative to that time sharing will control. It's entirely common to have equal time sharing and still have one parent owe a duty of support to the other. And that has to do with the fact that the incomes may not be equal. So the first step is to look at the income of the parties, and we generally look at the net income, and then we compare that with the number of overnights. I like to say that child support is very black and white most of the time. Oftentimes I'm asked if a parent can relocate out of state after the birth of a child or during the child's minority. And the answer to that always is it depends. If paternity has not been established, then technically a person can relocate. However, I typically advise not to do so unless you have a very compelling reason to do so otherwise. The court will look at that action in a negative light if it's determined that a child was relocated in order to avoid contact with that child's natural parent. If you're a parent considering relocation, the first thing that I recommend you do is to reach out to the non-relocating parent to discuss it with him or her first. If the two of you can come to an agreement, for example, that the minor child will then spend a majority of the summer with the non-relocating parent or spend a majority of the holidays with the non-relocating parent, then perhaps the two parents can work it out to avoid having to have a trial. If you're the parent that's seeking to relocate and you cannot come to an agreement with a non-relocating parent, then it is essential that you follow the letter of the law of the Florida relocation statute. You're going to have to file a petition with the court and serve it upon the other party. Your petition has to be extremely specific in accordance with the statute on divulging information as to why you're relocating and where you're relocating. If you're a non-relocating parent and you're looking for information on what to do, it's essential that you go to court pretty much right away. If somebody has relocated with the child without your permission and you have an established parental right to that child, you're going to need to take immediate emergency action and obtain an order by the court requiring that the parent relocate back with the child. You may contact me at the phone number provided. Our website is sharplawpa.com.